do want to make a further record that he still remains in his jail attire. Prior to the break, I did advise the captain and to let Mr. Brooks know that he certainly could take the opportunity during the lunch hour to put on street clothes. So it's his choice. He is here in the jail attire. He's at the table, continues to be masked. Welcome back, Mr. Brooks.
Just for the record, Your Honor, they never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked. I just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. Please be mindful, sir, that the right to be here can, of course, be lost if you engage in disruptful, discourteous behavior, if you interrupt the decorum and do not show respect for the judicial proceedings. You would, of course, be subject to removal and forfeiting your right to be present in this courtroom. All right, I'd like to bring the jury out, Mr. Brooks. I am still going through the preliminary jury instructions. I know you filed some objections. Those have been noted for the record, as I advised earlier this morning. Because I've approved of them, there should be no objections. You had ample opportunity to do that. So I'm instructing you at this point not to object, because I will consider whether that's being done for disruption. If you have an objection, write it down on a piece of paper, pass it to the bailiff, and I'll take it up outside the presence of the jury.
Just so I'm clear, are we talking about objections to strictly jury instructions, or the filings that I filed on the 3rd?
I'm not addressing those at this point, sir.
I was just asking for clarification. I didn't know which one you were speaking on as far as the objections.
I'm talking about objections during this court hearing to the court going through the preliminary jury instructions.
Okay, I was just asking for clarification.
Right, I'm not addressing any of those filings. I previously addressed those. It may not be to your satisfaction, but
I remember what you said, to be honest, about those.
And I'm not going to repeat myself. So the record speaks for itself. Your objections in those filings, to the extent, whatever they are noted. They're part of the record, and they will be available for you at a later point in time should you be convicted and on appeal to make whatever arguments that you need to or want to regarding those. But from my perspective, that is something I'm not going to take up any further. And any attempt by you to do that, I will have to consider whether that's being done to disrupt the proceedings and not for legitimate reasons.
My only reason for bringing it up was to make sure that they are offered into evidence.
Sir, we're not at the evidentiary phase. They're part of the record. They've been received. So at this point, there's no evidence to be taken. We're not at that stage of the proceedings. So you will have an opportunity after the state presents their case in chief and they rest, to then present your case and to present evidence that's relevant to the issues before the court and the jury. So I'm not going to go through any further on what that means. That would be for me to provide you with an explanation of the law or procedure, but I expect you to not bring that up at this point in time or going forward.
I don't understand, though, Your Honor.
Mr. Brooks, I've already addressed them. I'm going to bring the jury out. Please do not disrupt as the jury comes in and as I complete reading the preliminary instructions. I am, just for reference for everyone, I've read through 44 pages of 69, and so I still have a ways to go. My intention would be to finish with the preliminary jury instructions, take a short break for all, including the jurors, and then come back with opening statements. And that's, you have a choice, sir, at that point, whether you want to give one, but the state goes first because they obviously have the burden of proof, and then you would have an opportunity to give an opening statement as well. But that's my plan, at least for the afternoon.
I would like to go back over there, Your Honor.
You would like to, you're asking that to voluntarily be taken to that courtroom.
Well, I'm trying to seek to understand how the testimony evidence that was given could be considered
Mr. Brooks, I've already
evidence.
dealt with that. I'm not going to deal with it. If you want to go to that courtroom, are you waiving your right to be present right now?
Can I at least raise the issue of subject matter jurisdiction?
No, there's no lawful motion before the court. You may not.
Are you making a judicial determination that I cannot?
Mr. Brooks, I'm going to bring the jury out. I'd like you to stay. That's my preference that you stay. You've certainly demonstrated throughout these proceedings that you have the capacity to follow the rules, that you have the intellect to make cogent, coherent, articulate, responsive arguments when you so choose. But when you start doing what you're starting to do right now, going back to filings I've already addressed, and start talking about subject matter jurisdiction, that is a tactic by you that I believe is to disrupt and to delay the proceedings.
That is not accurate, Your Honor.
Your objection to my characterization of that is noted.
I would like to make a motion for finding a fact then.
Your request is denied.
On what basis?
Your request is denied, sir.
Your Honor, I'm merely seeking to understand on what...
Mr. Brooks, I refer you once again to document 244 that you signed, that you acknowledged, dealing with the right to waiver of right to attorney. We went through all of the advantages, the disadvantages. You were advised of things, including the charges that you face, the penalties that go along with them. We discussed the difficulty of representing yourself. You made a deliberate choice to waive your right to an attorney, which this court honored and granted.
That is
And
because
you,
I
Mr.
altered
Brooks,
the
don't
contract.
interrupt me. Okay, now that's at least the second time. So don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not
please,
my intent.
I'm not going to force you to sit down. You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that you want.
I'm not
All right?
asking for legal advice.
I cannot explain court procedures or the law to you. So with that, Mr. Brooks, that's another interruption. You keep going. Stop.
I'm seeking merely to understand, Your Honor. I don't understand the nature and cause of the charges.
Mr. Brooks, I've already dealt with these.
I'm trying to bring up the subject matter
Mr. Brooks,
jurisdiction.
if you keep interrupting me, then you will forfeit your right to be present because you're showing through your conduct that you will not follow the most simplest rule of civility in a courtroom, and that's by not interrupting. You continue to interrupt. It's been a couple of minutes since we've been on the record, and there's been a number of times you've already interrupted me. You claiming to not understand and you wanting to discuss subject matter jurisdiction, do not, it's just a tactic by you. The fact that you are doing that demonstrates to me that you came back over here, right, with absolutely no intention of following the rules.
If that's what you want to say, that's your assessment. It's not accurate.
Well, my assessment will stand on the record, sir. It's based on my observations.
And
So at this point, Mr. Brooks,
I respectfully object
stop
to that.
interrupting me, please.
I merely
Stop
just seek
interrupting me,
to
sir.
understand. I was
If
in the
you
middle
have
of
an
saying
objection, write it down.
something. I thought that applied to me being.
It's
from
applying right
another-
now since you keep interrupting me while I'm talking.
So what is the purpose of me being present if I'm not able to ask simple questions that I do not understand? I'm
Mr.
just
Brooks,
seeking.
I've been
I'm not
more
asking for
than
legal
patient
advice.
with you. And the issues that you keep trying to raise every time we're in here are not issues I'm going to raise at this juncture or address at this juncture in the proceedings.
Is there
All
a
right,
reason why?
I'm not giving you advice. I'm not explaining the law. I don't need to do any of that, sir. All right, you filed what you needed to file. I have addressed every single filing on the record. It may not be to your satisfaction,
That's inaccurate.
but I have addressed them.
That's
All
inaccurate,
right,
Your Honor.
some of your
With all
filings,
respect.
sir, you're interrupting me yet again because you're not letting me finish with my explanation. Some of your filings do not require a specific line-by-line response by the court. I've addressed them in the way that I believe the law requires me to do. Again, that may not be to your satisfaction, and that is simply the way that it's going to be.
It doesn't
But
have
we are
anything-
continuing on with the reading of jury instructions. It's important. They're going to come in, and it will be up to you whether you can demonstrate respect and courtesy, not only for these proceedings, but for the jurors that have been selected to hear this case.
Your
Madam
Honor,
Clerk, have the jurors brought
Your
in,
Honor,
please.
What you're doing is judicial misconduct. You're making the judicial determination that I'm not allowed to ask questions, that I'm not allowed to question Your Honor, which is my right. I've merely brought up subject matter jurisdiction because it has merit. I've merely tried to seek to understand the proceedings that I do not understand. You're rushing me to judgment by constantly removing me from the court when I should be present for all proceedings, and I should be able to understand, which I do not. Once again, I do not understand the charges, the nature of the charges against me. I do not understand why Your Honor will not answer mere questions that would give me clarification on understanding. I'm not attempting purposely to be disruptive, disrespectful in any manner. But if I don't understand something, it benefits me to ask so that I can have clarity. The waiver that you speak of with the attorney, I gave the waiver back in the way that I felt that it should be altered, and you said so yourself on the record that the word understanding was taken off of that paperwork that I sent back to you. That should have let you know right there further that I did not understand the proceedings, and that was some of the issues that I'm bringing up now. It's merely just clarification, Your Honor. I don't understand what is going on. It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the
Do
proceedings.
you
It is not to-
understand when I tell you not to interrupt me?
No,
Do you
no, I do not.
understand when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
I still would like to ask
Mr.
questions,
Brooks?
Your Honor.
Stop talking. We are proceeding with the continued advisement to the jury of these preliminary jury instructions. Do not interrupt me. The record should reflect that the jurors are entering the courtroom.
Your Honor, with all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. You'll have opportunity
I disagree.
later to raise other issues, but the issues that you seek to engage with this court are issues I've already addressed.
You have not. You have not shown proof.
Mr.
that
Brooks,
you have
the
not
jury
shown-
is in the courtroom.
I understand that,
You
Your Honor.
continue to talk despite being told to sit down and to pay respect to this court, to these jurors, to the process.
It is my right to stand or to sit, Your Honor. It is my right.
Mr.
I'm
Brooks,
merely
you can
exercising my right.
stand. You need to be quiet. Thank
Your
you.
Honor, Your
Mr.
Honor.
Brooks, please stop. I'm going to continue with the instructions. If you interrupt me, you will run the risk of being taken to the courtroom next door.
I'm seeking to understand, Your Honor.
Mr. Brooks, final warning.
I'm seeking to understand, Your Honor. It must be some clarification.
Mr. Brooks, I want you here.
I want to
Stop interrupting me.
be here. You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor,
Ladies and gentlemen of the jury,
you can
I'm going
move
to
me to the other
continue
thing.
with the jury instructions. I'm on count 38. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree reckless endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 40, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 40. If you are not so satisfied, you must find the defendant not guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41. If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 42, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant not guilty as to count 42. If you find the defendant guilty of count 42, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 48, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 48. If you are not so satisfied, you must find the defendant not guilty as to count 48. If you find the defendant guilty of count 48, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 49, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 49. If you are not so satisfied, you must find the defendant not guilty as to count 49. If you find the defendant guilty of count 49, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree reckless endangering safety have been proved as to count 50, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty of count 50. Sorry, I lost my place. I hope that was all related to count 50 because it was. I'll just start at the top of that again. If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 50, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty as to count 50. If you find the defendant guilty of count 50, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 51, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 51. If you are not so satisfied, you must find the defendant not guilty as to count 51. If you find the defendant guilty of count 51, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 52, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 52. If you are not so satisfied, you must find the defendant not guilty as to count 52. If you find the defendant guilty of count 52, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 53, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 53. If you are not so satisfied, you must find the defendant not guilty as to count 53. If you find the defendant guilty of count 53, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 54, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 54. If you are not so satisfied, you must find the defendant not guilty as to count 54. If you find the defendant guilty of count 54, you must answer the following question, found at all from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt, legal matters give you an opportunity as well for harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3. The defendant caused bodily harm without the consent of Erica Patterson. 4. The defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all four elements of battery have been proved as to count 76, you should find the defendant guilty of battery as charged in count 76. If you are not so satisfied, you must find the defendant not guilty. An information is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The parties will make opening statements. The purpose of an opening statement is to give the parties an opportunity to tell you what they expect the evidence will show you so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. Before we have the parties or before I give them the opportunity to make opening statements, I am going to excuse the jurors to address a few legal matters, give you an opportunity as well for a short comfort break. We'll let you know when we bring you back in. Number of pieces of paper that Mr. Brooks wrote on. I'm going to have them copied so the state can be aware of that and respond if necessary. So we'll just take a moment while those papers are copied.
You did call me. Did it not work?
I called them, but all right, I'll call again.
We will follow up.
How many copies are you making? 2? Yep, okay. We'll make sure you have copies of the filings as well, so you know what will be discussed, or at least addressed in some fashion. But I need to provide copies to the state. Go ahead, sir.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognized her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't want that to end up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs. So it was no way for me to even see who the jury was. Obviously, I wouldn't know them by name. If I would have been able to see the jurors, I would have immediately addressed that.
I will make this one indulgence. I'll have the civilian bailiff ask that juror if she was in attendance at your initial appearance out of an abundance of caution. These are jurors, though, who with the jury questionnaires were also asked what knowledge they had about proceedings they watched or even attended. And no one, to my knowledge, has disclosed anything like that, but out of an abundance of caution, we will ask that juror if she was in attendance at your initial appearance. So for now, that's how I'll address it. I'll advise you of what her answer is later.
Do we know the number?
Do you know the number of the jurors, sir? They have numbers.
I just know I can't see the number from here. I just know the chair she was sitting in.
Which chair, sir? Top row or the top
row,
or the bottom row?
The bottom row, the last black chair. Black shirt. She had the black shirt.
They're all
on.
black chairs, sir. So
the last black chair closest to the television.
Thank you, sir, because there are two sides, right? So there's the last chair on both sides. So I wanted to make clear. You're saying the chair closest to the television. Thank you.
I said that at the beginning, Your Honor.
Front row. All right. State have copies of the filings?
Yes.
I will take these in order. The first is a note from Mr. Brooks that was handed to Deputy Wittig at about 12:05. It says, I would like my filings addressed, parenthesis, notice of special appearance, statement of particulars, both both are by affidavit filed 10/3/22, which today is deadline to respond. Thank you, Mr. Brooks. I'm respectfully declining to respond to those filings. That's my decision, sir. Next
Are you
topic.
making a judicial determination that those have no merit?
Mr. Brooks, I have indicated to you on the record what I will or will not do.
I would like to motion for finding of fact.
Your request is denied. The next,
May Your Honor explain why it
Mr.
is
Brooks,
denied.
I'm going to go through these one by one. If I feel the need to make more of a record, I will do so. The record will be available later on. If you think I've made an error, you can then raise that on appeal.
I know you're making the error, Your Honor.
Mr. Brooks, I'm not going to have a debate with you right now. We are continuing on. I'm giving you the courtesy to respond to each one of these things. That's how I've responded. I expect that you will, even if you disagree with my decision, sir, that you will respect it and we'll move forward. The next piece of paper filed at 1:52 p.m. says, are you making a judicial determination? I'm not allow my right under the First Amendment to freedom of speech in this courtroom. Mr. Brooks, we have rules of decorum and courtesy. They have been provided to you multiple times. They are part of the materials that you have before you.
Do they fall under the First Amendment?
SCR Chapter 62 discusses just the standards of courtesy and decorum for the courts of Wisconsin. In addition, sir, parties are able to file requests with the court. It's called a motion. A motion, however, is based in law. There is a citation to not only that law, but relevant facts, and there's a request for relief. While you have the right to present a defense, you do not have a right to disrupt the proceedings.
That was not disruption.
Mr. Brooks.
I was asking, will my First Amendment right, which is freedom of speech, and the right to be heard in court, will that be honored by Your Honor? That's a valid question.
Mr. Brooks,
that's a constitutional
I
right.
have given you ample opportunity to present information, evidence, to question when we've had witnesses on the stand, but I expect you to follow the rules of procedure, the rules of evidence when presenting your requests.
I can't even get these admitted into evidence.
That's, Mr. Brooks, I cannot explain to you if you don't understand the basis in law for the denial.
You're right, I don't understand. But
that doesn't mean we're going to have a discussion or a debate about what it means, because we're not going to do that.
The rules that you set.
So the bottom line is, I don't feel, Mr. Brooks, stop talking. I was
following the rules when you said that I had to make all objections.
And you did, and I'm going through them, so give me the courtesy of replying or responding to these. And please give me the courtesy that even when you disagree with how I answer them, that you will not interrupt me.
It's not about me trying to interrupt you, Your Honor.
Mr. Brooks, I'm going to address the next one, so please pay attention.
What you were saying about decorum, I was asking, does that fall under the First Amendment? Because the First Amendment, which is my constitutional right, says that I have the right to freedom of speech and to be heard in this court.
Mr. Brooks, again, you have the right to present a defense, but that right is not unfettered. That right, Mr. Brooks, you are interrupting me. Stop.
Because you're talking about
because you're purposely doing this, so I can't get my reasoning out. You make it incredibly difficult.
I'm not referring to the Sixth Amendment.
Mr. Brooks.
I'm referring to the First Amendment, which clearly says that I have the right to freedom of speech and to be heard in the courtroom. Are you not going to honor my constitutional right, Your Honor? If not, that is judicial misconduct, and you're making a judicial determination to not honor my constitutional right. I just want to be treated fairly, like anyone else, which you said on the record that you will be fair and impartial.
Mr. Brooks, you also have an obligation to treat this court fairly, and you have an obligation to follow the rules of courtesy and decorum, the rules of procedure, the rules of evidence.
Your Honor,
That's the playing field that you willingly entered into and made a deliberate decision to waive your right to an attorney and to appear in this case as your own attorney.
To represent myself pro per. The same paperwork that you gave me, you have, and I also have a copy of the same one where I scratched out what I did not agree or consent to. We both know that, Your Honor.
Mr. Brooks, I made findings regarding that, and those findings stand. That despite you scratching out some of those words on there, I made very specific findings about your waiver of right to an attorney. So we're not going to relitigate that here right now.
You also accepted the terms of the paperwork that I filed out.
Mr. Brooks, I'm not going to engage with you about whether you and I have entered into some type of a contract.
We did not.
Or engage in any type of that kind of dialogue, because that's what you're claiming through some of these filings, and you've said that previously.
I am not claiming that, Your Honor.
So,
in any way,
Mr. Brooks, I'm giving you some leeway. You continue to talk over me. It's I'm asking you to follow the rules of civility. Simple rules, sir. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to and then hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's being asserted on my
Here's what's happening, sir. I'm telling you, I'm advising you to respect the rules. I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. And then I'll bring you back when the jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is clearly not following the simple rule of civility that I have established. He continues to interrupt. He's not providing this court with ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Will Your Honor honor my First Amendment right?
I'm not answering that question, sir, because I've already addressed it.
So you're making a judicial determination to deprive me of my constitutional right?
I am not making any such determination, sir.
So you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've already answered the question that you have a right to present a defense.
That is the
You have a right to be present.
You're trying to twist
You
up the
have
amendments.
a right to present your defense, but your rights are not unfettered.
Yes, they
your
are,
rights.
Your Honor. You're citing the Sixth Amendment, which I am not
Mr. Brooks,
questioning.
Your First Amendment, in some respects, is circumscribed by the rules of evidence and the rules of procedure.
Does it say that I have
So that doesn't
freedom of
mean you
speech?
get to say anything that you want in front of a jury.
Your
And
Honor.
it doesn't mean you get to put forth any kind of evidence that you want
Your
in front
Honor,
of a
am
jury.
I
What
being-
it means, sir,
am
is
I being
that you
disrespectful?
must
Am I
follow.
calling you
Yes,
out
you're
your
being
name? Am I threatening
disrespectful because
anybody?
you're
I'm not doing anything of the sort.
All right, he is continuously talking over me. So at this point, I'm going to find that he's forfeited his right to be present as I go through
I
his
have not consented to any.
his paperwork. He's to be removed to the other courtroom until such time as he can pledge to follow the rules of decorum and civility. We'll be in recess until we have
Your Honor,
everything
I do
set
not
up.
agree to a
The record to reflect, I'm stepping off.